Good afternoon, everyone. Thank you for joining us for this webinar series that we've been having this year. Today's presentation is a sneak peek into our latest report that will be released tomorrow. And we're really excited to have Carmen, the Campaign for Youth Justice Policy Director, with us to talk about her findings. The goal of our webinar series is to offer technical assistance to our state, strategic, and at-large partners to provide answers to the most asked and the most difficult questions to answer. We offer office hours for one-on-one follow-up to any questions you may have, and I can be contacted at my email, jsandoval@CFYJ.org, or at 202-821-1605 is my direct line. I want to tell you a little bit about our speaker today, for those of you who are not familiar with Carmen or her work. But here at the campaign, Carmen assists both state-based organizations and national partners in developing policy goals related to criminal justice reform. But before coming to the campaign, Carmen served as the Deputy Director and Staff Attorney for Advocates for Justice and Education here in DC, a nonprofit formed to educate parents, youth, and the community about the laws governing public education, specifically for children with special needs. In that role, Carmen provided direct representation to families in special education and school discipline matters, and also provided training to families on various disability topics. In 2008, Carmen was also appointed to the DC Mayor's Juvenile Justice Advisory Group, where she works with city stakeholders to provide recommendations on district compliance with Juvenile Justice and Delinquency Prevention Act. She also co-chairs the American Bar Association Individual Rights and Responsibilities Public Education Committee, which seeks to protect and advance the right of equal access and opportunity to public education for all people. Carmen received her undergraduate degree from Vassar College and her jurisdictorate from Tulane University School of Law. So we're excited to have Carmen tell us the latest and greatest in research around the adult system today. I am going to turn it over to Carmen to tell us what she's found in terms of what's happening across the country with PREA's Youthful Inmate Standard and the state of young people in prisons across the country. Thanks and welcome, Carmen.
Thank you, Jessica. I appreciate that, and thank you all for attending this webinar. I wanted to allow those on the call to get a sneak peek of what will be released tomorrow. We have sent a few embargoed copies around, but I'm going to share a few of the highlights that we found while looking into how states are complying with the Prison Rape Elimination Act Youthful Inmate Standard. And I think it's important to know why we created the report and why now and how we did it. And basically at this point, PREA was enacted in 2002. Regulations for PREA came out in 2012. We thought now would be a good time to see how states are coming into compliance with the PREA's Youthful Inmate Standard in light of the technical assistance that's available to them, in light of the funding, and in light of the political will to make some changes. In order to do this, I researched federal, state, and local laws and practices affecting youth in the adult system. You'll see in the report, once it's released tomorrow, that perhaps the name is a misnomer, and it's better suited to say it's a Trojan horse to provide some new information around kids in the adult system, in addition to understanding how states are complying with PREA. I did FOIA requests to all of the state prison systems, to the State Department of Corrections. I did telephone follow-up calls with many of the state DOCs, especially those who did not want to send things in writing to us, but rather would have wanted to have a conversation with us about how their policies are played out in the prisons, and especially for some of the states that had actually no written policy on how to house kids, which still exists in some states, so they wanted to have a conversation with us about that. So what this report really shows is it highlights a checkered state-by-state system and disparate outcomes among groups. Some of the report highlights. Like I said, in 2003, the Prison Rape Elimination Act was enacted through a bipartisan Congress and unanimously passed by Congress and signed into law by George W. Bush. Prior to its enactment, after its enactment, there was a National Prison Rape Elimination Commission constructed and appointed by the Congress and by the President to look at the issue of prison rape. And one of the issues that kept coming up were the number of youth held in adult facilities. PREA covers jails, prisons, lockups, community, shelter homes. It covers all of those facilities. And testimony that came up during the Prison Rape Elimination Commission hearings were the number of youth being held in adult jails and prisons and the number of sexual abuses that occurred to youth in these facilities. So what the National Prison Rape Elimination Commission recommended in its standards, in its draft of standards, was for a full removal of youth in adult system. And, short of that became the Youthful Inmate standard, and those are the regulations promulgated and enacted by Congress and by the Department of Justice. So the PREA Commission released a report in 2009 of all of its findings prior to the standard being enacted. And they said, as a matter of policy, the Department of Justice supports strong limitations on the confinement of adults with juveniles. And they also went on to say, more than any other group of incarcerated persons, youth incarcerated with adults are probably at the highest risk for sexual abuse. What does the Youthful Inmate Standard actually say? It says a couple of things. PREA develops regulations requiring sight and sound separation of youth and adults in prisons, lockups, jails, any of those. But what we are focusing on in this report is specifically prisons. PREA's Youthful Inmate Standard also says adults and youth may not be in contact to see or hear each other except when directly supervised by staff. And this piece of the standard really goes to looking at how, what do you do with youth when they're in common areas like a cafeteria or the workout area. So it really goes to say that these young people should not be in contact, and if they have to be, if it's just physically impossible to separate the two populations, which we learned in many states it is, then those youth have to have almost one-to-one supervision by staff at all times, whether walking to the medical unit, walking down the hall, any of those things, they require direct supervision. It also says adults and youth may not be housed together. They cannot share sleeping quarters. And a piece of this that in addition to those items, it also says states should do their best, and doing your best is a very low bar for many states. But it says states must do their best to not use solitary confinement or segregation as a way to meet these ends. So what are the penalties if states aren't in compliance with PREA? Well, there are a few federal dollars that go to states for criminal justice reform or law enforcement or juvenile justice efforts, and states are in jeopardy of losing 5% of those funds every year if they aren't in compliance. And currently, DOJ identifies those pots of money every year and has to put states on notice that these are the pots of money where they can lose money. And this year it was the Burn JAG funds, the JJ, Juvenile Justice and Delinquency Prevention Funds, and also the Violence Against Women Act funds. So states who are not in compliance with PREA risk losing that funding. So I will just add around the funding piece because I think that has been a source of confusion or aggravation for states because the standards came out in 2012 and there was a mad rush for states to develop their own policies and procedures and standards. And also, as a requirement of PREA, they have to audit a third of their facilities every year. So what you had found was most states said they were not in compliance. However, there's another option for states, and that's checking off a box that says we're making assurances that will come into compliance in the future. So the three options that the federal government gave states around PREA compliance was full compliance, which only a handful of states were able to say they're in full compliance with PREA. Make assurances, so in essence saying we're not quite there yet, but we promise to make an effort to come into compliance as the years go on. Or they could say we absolutely are not going to come into compliance and we're not going to provide the federal government with any information other than thanks but no thanks. And we have 4 states that did that in 2014. And those states were Alaska, Utah, and I'm can't quite remember the other two off the top of my head, but it's interesting to say, and I can, as we go on, kind of point to the fact that those states that said thanks but no thanks are also states that house youth, and so it calls into question, great, so now you said you're not going to come in compliance with the Youthful Inmate Standard, but you're housing these youth, so how are you doing this safely? What also is interesting about the Youthful Inmate Standard is it's one of the first federal statutes that define youth as anyone under the age of 18. And the Juvenile Justice and Delinquency Prevention Act allows states to decide their age of jurisdiction. However, Youthful Inmate Standard says that anyone under 18 falls under the protections of the Youthful Inmate Standard. And so what makes this complicated is that we have 9 states where the age of court jurisdiction ends well before the age of 18. New York and North Carolina are 2 states where at 16 you're automatically considered an adult, and in 7 other states like Missouri, Wisconsin, Louisiana, Georgia, South Carolina, and Michigan, kids at 17 are automatically considered an adult. So those states are, as you can imagine, and Texas, are also grappling with this issue of the federal government is defining these young people as adults, but our state government does not see these young kids as adults. And so there are some states that fall into that category that are currently working with the Department of Justice to figure out how they can come into compliance with the Youthful Inmate Standard, even though their state statutes say something differently. So what we have found in this report in 2013, and that's the latest data from the Bureau of Justice Statistics, 37 states kept youth in state prisons, and their state laws vary widely, often showing that programming is rarely tailored to meet the needs of the young people, often showing that states didn't go much further than copying PREA's Youthful Inmate Standard into their policies. And we have to remember federal laws are usually just the baseline of compliance and standards. States oftentimes go above and beyond those standards or the baseline law. Oftentimes they just do the minimum. And in this case, we're really pushing states to be creative or look further than just the minimum standard here, and that's the sight and sound separation. And I'll go into recommendations at the end. So what we
I would
found,
like to interject real quickly, Carmen, is for folks who are listening in, we are going to open this up for questions at the end of the presentation through the chat function. And I just want to remind everyone to feel free to submit any questions you have during this presentation in the chat box.
Great. So what we found over the years, and specifically in this report, are that 11 states limited power to transfer youth to adult systems. 7 states, which are listed here, reformed their administrative practices to comply with PREA, and those states are Alabama, Hawaii, Missouri, Nevada, Pennsylvania, Indiana, and North Carolina. And when we say reformed administrative practices, basically these are states that have said, yes, we will come into compliance with the Youthful Inmate Standard by having the Youthful Inmate Standard language in our policies and procedures and doing our best to keep kids sight and sound separated. However, I can tell you nationally there are still too many kids in adult prisons. There are 1,200 youth on any given day across the country sitting in an adult prison right now. And so just simply doing the de minimis amount of work here, just stating the Youthful Inmate Standard in their policies does not mean that they're actively engaged in prison reform at this time. What's interesting, too, is what we found is that there are 6 states currently that have a minimum age for state prison placement. These 6 states said, all right, we're not going to house anyone under 16 in our state prison system. So we have Arkansas, Delaware, Montana, Vermont, Tennessee, and Arizona. Excuse me, that's not Arizona, that's Arkansas. And the first one is Alaska. Excuse me, 5th grade geography class has failed me. But so these 6 states said 16 is the minimum age you can come into our prison placement. Obviously, we would ideally like to see that raised to 18. However, these states are making some efforts to say, hey, we understand kids are too young to be in our prisons. Let's set a minimum age here. And it's interesting that only 6 have done that, understanding the harms that affect youth in adult settings. Sorry, the slide changing is very slow. All right. So then we have states who have developed what we call these youthful offender programs, and the name is a misnomer, I would say, because oftentimes these units hold youth defined much broadly than those under 18. A place like Washington, Iowa, Delaware, Pennsylvania, and Colorado, most of those states consider a youthful offender unit from 18 to 25. So you're still placing youth under 18 with older youth, which goes against the youthful inmate standard in practice and in policy. Even still, many of these youthful offender programs don't have all the services necessary to really help youth become rehabilitated. Successfully, there have been states that have just said the only way we can come into compliance with PREA and the only thing that makes sense for us is to fully remove youth from the state prison systems. And those states are Hawaii, West Virginia, Maine, California, and Washington State. So through our research in looking at kids in adult prisons, this is what we found, the number of youth on any given day. And we showed the total youth in every state and then went a little bit further and looked at the male and female populations. Because something we have found in our studies of kids held in adult facilities is not only are kids at a great risk of sexual abuse and use of solitary confinement, girls face some of the greatest issues and isolation practices when housed in adult facilities. So you can see the states that in 2013 did not house any youth, and then you see some of these outliers here. A state like Florida on any given day has 144 people under 18 in their state prisons. A state like Georgia, where at the age of 17 you're automatically considered an adult, you have 92 kids held in state prisons. Michigan, also one of those states where at age of 17 you're considered an adult. They have 73 kids on any given day, and a big state such as New York has about 131. I think what's very interesting is looking at the female populations on this list. So while New York has 131 young kids in their state prison, only 4 of those are female. So it begs the question, what is happening with this young female population when you only have 4 girls? And what we found in a state like Connecticut, which also has about 88 people under 18 in state prisons and only 2 females, they place those females oftentimes in women facilities. And in our conversations with the heads of the Department of Corrections there, they were very honest and said, we are unable to separate these young women without placing them in solitary confinement because there are just too few of them. And so I think that story resonates with most of us, is why are these kids there in the first place? And how are states actively engaging in PREA youthful inmate compliance with such few young people? So I'll leave that up for a second just so you guys can see other states. Another standout is Texas, where, again, the age of court jurisdiction ends when the young person turns 17, and Wisconsin. So what we also found in our research is that the number of youth in adult prison systems has dropped 70%, a huge amount from 2000 to 2013. In 1995, there were over 5,000 youth in state prisons on any given day, and now in 2013, we're looking at 1,200. We believe a lot of things contributed to this decrease. One, we've been documenting state reforms since 2011 at this point, looking at state laws that passed since 2005, showing the reform efforts and this wave of reforms looking at kids differently. There's been an education of prosecutors and judges when dealing with kids who are allegedly committing offenses that could be considered adult offenses. And we also have a lower crime rate. The rate of juvenile arrests has dropped tremendously over the years. And so what's interesting is despite this large drop, we still have 1,200 youth in state prisons, and 30% of these youth are in prison for nonviolent crimes, oftentimes drug offenses. And this is just some more of what I said before, some of those state outliers there. And I will add that most, if not all of these states have engaged in state policy campaigns to either raise the age or change some of the transfer laws in light of understanding that there are way too many kids entering into the adult system. So we have an active campaign in Florida. We're working with New York. Michigan just introduced quite a package of bills to look at kids in the adult system. Texas had some heavy advocacy last year looking at raise the age. North Carolina has been exploring raise the age for the last nearly 10 years. And Illinois was successful last year with limiting the number of kids who automatically enter the adult system. So this is just a visual of seeing how the rate of incarceration has dropped. We saw, I think it helps to see this massive drop from 2000 to 2013 in red, and then in green, looking at the federal prison system. So what's interesting about this, yes, kids can be tried as adults in our federally, but as a best practice, the federal government does not place kids in adult facilities. So you will not see anyone under 18 in a federal bureau of prison. Instead, the federal government has decided to contract with state juvenile facilities to place this small number of youth who are tried as adults in their juvenile facilities. So, we always highlight that as a best practice, right? I mean, ideally, we wouldn't want these kids tried as adults, period. But once you get to the sentencing phase, the federal government said, we're not going to expose these young people to the harms that they can face in a Bureau of Prison adult facility, so we'll contract out. I think something that really struck us, and I don't think is a shock, but it's still very striking, looking at the racial disparity of kids who enter the adult criminal justice system. They are disproportionately placed in adult prisons. So if we look at the overall population of African American youth, they're 17% of all youth. When we look at arrest, they're about 26% of arrests. Those being transferred are nearly 50%, and then unfortunately those entering state prison are 58% of the youth populations. So as we go deeper into the criminal justice system, the disparities are grave, and I think if anyone's really trying to look at racial and ethnic disparities, kids in the adult system is a good place to start. Before I get into that, I just want to add one more thing about racial disparities. What we've seen looking at the adult court transfer process is judicial waivers, basically the mechanism which allows juvenile court judges to decide if a child should be transferred to the adult system. We've seen that racial disparity, that racial gap, get smaller over the years, and we've seen the number of waivers decrease over the years through that mechanism. Unfortunately, what we don't have data on and what's making up most of this gross disparity are those mechanisms that automatically allow prosecutors to bypass a juvenile court and prosecute a child under 18 in an adult criminal court, and also those laws that just statutorily exclude kids from being seen in a juvenile court in the first place. Maryland, there's a list of 33 offenses where kids are automatically excluded from the juvenile court and will go straight to an adult court. And, fortunately, there are strong advocates in Maryland looking at these 33 offenses, some of them nonviolent offenses, to sort of chip away at those nonsensical statutes. All right, some of the more uplifting things. right? This is just a horrible subject, talking about prison and kids in prison. So now we move on to the sexual abuse, let alone the racial disparities of kids in the adult system. What we know, and this was a study done by the Bureau of Justice Statistics, they looked at all of the 16 and 17-year-olds in jails and prisons across the country and administered a survey to them. And 76% of those youth who reported sexual abuse in the surveys stated that they were abused repeatedly by staff. So, red flag. You were talking about 3/4 of the kids who actually would admit being abused, which we also think is a very low number, but the fact that 75% of them said they were repeatedly abused by staff should be cause enough to remove all of these young people from adult facilities. Under 10% of those youthful inmates who stated that they were abused reported the abuse to anyone. So 90% of those young people sitting in jails, prisons, locked up, do not feel safe enough to even report this abuse to their family members when it's happening. The Bureau of Justice Statistics, which is run through the Department of Justice, also found that 66% of these youth who reported sexual abuse stated that they were abused repeatedly by other inmates. So these are probably other adult inmates or other youthful offenders in their units. 79% of those youth who reported being abused experienced physical or threatened force while they were being abused. So the research is very clear. The adolescent brain development research is very clear to us. There are major problems with placing youth with adults. One of the main reasons states and policymakers say that it's necessary to transfer youth is to increase public safety and decrease recidivism. Data has shown the exact opposite. The Centers for Disease Control and Prevention and the Office of Juvenile Justice and Delinquency Prevention have found that youth who are transferred to the adult system are 34 times more likely to recidivate than similar youth kept in the juvenile system. As a policymaker, if I saw those numbers, I think I would be very quick to say something has to change. If I knew that if I'm going to send 100 kids into the adult system and 34 of them are going to come back and recidivate oftentimes more quickly and more violently than youth I send to the juvenile system, then you bet I would, question the policies that exist now. So what's interesting about the CDC report, the study controlled for youth's socioeconomic background and past criminal record. So try to make it as apples to apples and as clear as possible to say that the system and the policies of transfer youth to the adult system aren't working, and they actually increase recidivism and are terrible for public safety. So at the end of the report, our big thing is recommendations. What can be done? I think the big elephant in the room is prohibit placing youth in adult prisons by law. And what's I think some pushback we get is, well, aren't these the worst of the worst kids? And what our research has shown us that no, they aren't the worst of the worst kids. Only about 5% of the kids who are arrested are there for violent offenses. And as the slide said previously, about 29% are there for nonviolent offenses. So the first thing is we recommend that state statutes are updated to prohibit the placement of youth in adult prisons. I think it's important now to reflect the original intent of the Juvenile Justice and Delinquency Prevention Act law in accordance with what the American Correctional Association's policy has said, which they also support the full removal of youth from jails and prisons, and really looking at the harms that affect kids when they're in adult jails and prisons, specifically prisons in this report. A second recommendation we had is place youth sentenced as adults in juvenile justice facilities. So we're not saying necessarily release them to their communities. I think that's a case-by-case risk assessment necessary to look at the needs of the individualized youth. Too often, as we say, when kids enter the adult system, the systems are too fast to look at the facts of the case and not the facts of the kids, and really understanding their needs and what's going on in their circumstances that have placed them there in the first place and what they truly need to become rehabilitated. Our hopes and our philosophy is that's what the juvenile justice system was created to do, was to rehabilitate. The third recommendation we have is looking at and implementing tried and proven approaches to removing youth from prisons. We recognize it can't happen overnight. We hope states take the time to study the issue of the number of kids in prisons and come up with some kind of coherent plan to move these kids appropriately to the appropriate facilities. And a big missing piece of the work we do is data. It's nearly impossible to find all of the data we need looking at kids who end up in the adult criminal justice system. Many states don't require courts to or prosecutors to report on the number of youth who have been transferred into the adult system, so they become lost. And especially looking at those states which have 1, 2, 3, 4 mechanisms plus 35 statutory exclusions that allow youth in the adult system. It's so necessary to have that data to understand patterns, to understand perhaps are there jurisdictions within states that are prosecuting more kids? Are we looking at more racial and ethnic disparities? Are we talking about justice by geography? What's happening in these states? And it would be impossible for policymakers to make smart changes without having this data in hand. So a few questions that I don't know if you wanted to go into questions, Jess, but I see a few here.
Yeah, I do have some questions that have come in, so I can go ahead and go into that piece now if that's want to end the recommendations here.
That's all I got.
Okay, thank you. Very good. So one of the question is, where can I get the full report with more information on states? Is there a place where people can go tomorrow once the report is released?
Sure. I would be remiss and if I didn't tell you guys where to get the report. So you could probably find it around, if people are really eager. I think our embargoed copy comes out at midnight. So for those really eager to get their hands on this for some light reading in the evening, then yes, you can go to our website, www.cfyj.org, and that will be on our banner page there with access to the full report. Or if you're looking to just get a summary, there's also an executive summary attached to that.
Great, thank you. So some other questions that have come in are, can you tell us, you mentioned the data piece, can you tell us how many states actually collect data on youth tried as adults?
Sure. I don't have recent numbers, but as of, I would say, 2010, 2011, about 13 states provided numbers to the federal government around transfer. States do collect data on judicial waiver, the courts do, and like I said, we've gone from about 13,000 waivers in early 2000s to about 5,000 to 6,000 as of 2013. So a huge, almost 50% drop in the number of kids who are judicially waived. But again, only about 13 states report data around the whole picture of transfer and waiver to the adult system.
Okay, well, that's helpful. Can you also kind of, you give us a list of the I states, of which, Florida was at the top of that, and you talked a little bit about how every state kind of is addressing these issues. Are there any states that we can point to as model states?
I would be reluctant to use the term model. All states, right, until we see a full removal of youth from adult prisons, I would not use the term model. So I would look to those states that have done that successfully, and those are the states that have those zeros. For the most part, those are states that have the zeros by their states. The only difference is some of those states may historically have kids in their adult prisons, and you'd have to do a comparison of the states that, like in Maine, says we will not ever house kids in our adult facility, and so they will forever remain a zero, as opposed to some other state that just the day that they do the prison survey, they just don't happen to have any kids in their facility. So and that varies state by state. But as far as model states, always looking at the states that have removed kids completely would be the way to go. On some promising practices, I would say, in light of PREA, is a state like Kansas. They no longer house their 16 or 17-year-old males in adult facilities. Instead, they've contracted with their neighboring state of Nebraska to house these offenders in a Nebraska facility for youth specifically. So that's something that states are doing, looking creatively on ways to safely house young adults.
Great. Thank you. One of the other questions that came through was, you mentioned that many institutions have done research on this issue of youth in the adult court, and really all of it points to how really terrible it is. Is there kind of something that you can summarize for us that helps us understand why states are reluctant to kind of update their laws and policies reflect what the research says?
So, Jess, you're going in and out, but I think the essence of your question is, why are states reluctant to remove kids from their adult prisons? Was that?
Yes. That how come states are reluctant to kind of update their policies and laws to reflect what the research says?
Sure. I think there are still policymakers who are stuck on this notion of from the 90s that kids who commit adult crime should get adult time, and that there are some people who believe incarceration really is the answer and that it solves all problems. It removes these quote unquote dangerous people from our society. I think that's short-sighted for what the data and the research tells us. It's also short-sighted because 80% of the kids who enter the adult system before the 18th birthday will come out before they're 25. And so now you have a new generation of young people who have lost the opportunity to vote before they even got it, have lost educational opportunities, who've lost vocational opportunities, and have really been disconnected and probably lack positive social interaction. So you're bringing this whole generation back into communities, and you can only imagine what that does to communities, what it does to that young person who now has no job prospect, no educational prospect, and has to rely back on the government for resources. So I think if policymakers really connect those dots and can see the full picture and the full kind of lifespan of a young person and what that one decision at 14, 15, 16, 17 does to them through their 50s, 60s, 70s, and really that cost analysis is needed, and it's rarely done because legislators are looking at that one-year state budget, or if you're lucky, a 2-year state budget cycle, and not looking down to 30, 20, or even 10 years from now.
Mm-hmm. Yeah, I think that's all very true, and I think as a way kind of to wrap this webinar up, I think people want to know what, as state advocates, what can they really do to get this issue on the map, what they can do to assist remove kids, kind of what are your recommendations around what our advocate friends out there listening can do?
Absolutely. And, as I pointed out, there are so many state campaigns happening now and state efforts to look at this issue of transfer and look at what the laws of the 90s have done to communities and starting to roll back those reforms. I think the most important thing is finding allies and coalition members to work with you. It's not enough just to have lawyers on a team or grassroots organizers. You need clergy, you need families, you need teachers to all have and speak with one voice about this issue. And in order to do that, you need to know the data, and that's what's really lacking. Doing those FOIA requests to your county and state courts to say, where are these kids, what are they being charged with, and what are their outcomes. And I think that's always a good place to start, is finding like-minded allies and digging into the data, and that will help form some of the policy recommendations that you make to your state legislators.
That's great, Carmen. I think that's it for the questions. So we can go ahead and hopefully I'm able to be heard during this closing. But I want to thank all of you who've joined our webinar today, and obviously to Carmen for putting out this really great report that's going to be released tomorrow and giving us a sneak peek into it today. Remember, you can call us for any one-on-one assistance with this particular topic if you want to drill down or have more specific needs kind of not addressed by today's presentation, or if you have questions about how to do a FOIA request and those kinds of things, please give us a call. Thank you. And this recording will be available on our website in the coming days. If you have any questions, please contact me at 202-821-1605 or at jsandoval@cfyj.org. Thank you and have a great day.